Okay, this is a panel about campaign finance after Citizens United. And Citizens United is already one of the most widely discussed cases of the political season. We have 2,300 Lexis hits at this point, and the only case that I can think of in recent history that's been discussed in the State of the Union address. We have here what is a balanced and hopefully fair panel. There are 2 alumni of Penn Law School and 2 professors. There are 2 people who have graduated from law school in the 20th century and 2 in the 21st century, and 2 Democrats and 2 Republicans. Judge Stewart Dalzell graduated from Penn Law School in 1969. From 1970 to 1991, he was in practice at Drinker, Biddle, and Reeve. He worked on Thatcher Longstreth's unsuccessful mayoral campaign. He spearheaded the successful effort to keep Frank Rizzo from changing the Philadelphia charter to become mayor for life. And he was both the treasurer and counsel to Congressman, then Senator John Hines. And in 1991, he was appointed to the Eastern District of Pennsylvania Court of the United States and has flourished there. Andrew Morton, on the far side, is the other representative of the real world. Andrew graduated from Penn Law School in 2000. Previously, he had worked as a campaign consultant and campaign manager. He spent the last 10 years as a member of the political law and government relations units at Latham & Watkins, Foley & Lardner, and he's now general counsel of Newdy, a software development corporation. He drafted an amicus brief in Citizens United. Kim Roosevelt, in the center here, to my left, in many ways, graduated from Yale Law School, clerked for Judge Stephen Williams on D.C. Circuit, Justice David Souter on the Supreme Court, joined Penn Law School in 2002. He teaches constitutional law and conflict of laws. He has books on conflict of laws and constitutional law, as well as a novel, which outsells both of them. And he also represents a detainee at Guantanamo. My name is Seth Kramer. I've been teaching at Penn Law since 1981. I clerked for Judge Arlen Adams on the Third Circuit after graduating from Yale Law School, and I am what the first President Bush referred to as a card-carrying member of the ACLU. I serve on the ACLU legal committee for both Pennsylvania and Philadelphia. So what we're going to do, we're going to begin with Judge Dalzell, who will set the scene and set out the case. I'll provide some critical reflections on Justice Kennedy's majority opinion. Andrew will provide some real-world counterpoint and discuss the intended and unintended effects of campaign finance. And Kim will conclude by discussing some of the broader theoretical issues that are raised by this case. Judge Dalzell.
Thank you. Well, first of all, I want to disclose a certain bias here, and that is that, as Professor Kramer just pointed out, for 15 years before I came on the court, I had regular, sometimes daily, dealings with the Federal Election Campaign Commission and the FEC. And in that 15 years, I'm happy to say the good news is that we never had an unfavorable experience ultimately with the FEC. But I can also disclose to you that I learned in those 15 years that if your taste runs to Kafkaesque experiences, the FEC is the agency for you. Sort of within the meaning of Shelley Duvall famously saying to Woody Allen and Annie Hall, making love with you is a Kafkaesque experience. Of course, she added, I meant that as a compliment. But anyway, so lest you think, though, that my views are just sour grapes from a former regulatee, I want to read to you what 7 former chairmen of the FEC said about the agency that they used to head up. They pointed out to the Supreme Court that their agency had complex rules on 71 different entities. Those entities are subject to separate rules for 33 different types of political speech. The agency has adopted 568 pages of regulations, 1,278 pages of explanations and justifications for those regulations. They've issued 1,771 advisory opinions since 1975 through the date of the Citizens United decision, which was January 21 of this year, and so on and so forth, which led the court to summarize all this, that the FEC has created a regime that allows it to select what political speech is safe for political consumption by applying ambiguous tests. So the background of this case goes back to a case called Buckley versus Vallejo, which was decided on January 30th, 1976, a date I well remember because I had become treasurer and general counsel to then Congressman Hines in December of 1975 and was laboring with the 74 amendments to the Campaign Act, which had both campaign contribution limits that we all have come to know, but more importantly, expenditure limits. And we were wrestling with all that when the Supreme Court came down with Buckley, which sustained the contribution limits, but held that the expenditure limits were unconstitutional. And so they were struck down by the Supreme Court. It also introduced a regime that's very important to understand Citizens United, and that is the difference between candidate contributions and expenditures and independent expenditures. And independent expenditures, and this has been confused a lot in the press talking about this case, we are not talking about in Citizens United contributions to candidates. We are talking about independent expenditures, which is a term of art under the Campaign Act. And that term of art means, by definition, that you can't have consultation of any kind with the candidate committee about what the content of the independent expenditure ads have. So the FEC developed over the following 15 years before I came on the court with a whole series of these regulations that the chairman talk about and that are quoted in Citizens United, and it's a very complicated regime to say the least. It was in this context that the court's jurisprudence following Buckley developed. And on the independent expenditure side, the most important case by far, and it's key to understanding Citizens United, is a case, Austin versus Michigan Chamber of Commerce. And in the state of Michigan, they had limitations on corporate giving for independent expenditures. And the court in Austin, a sharply divided court in Austin, held that they were constitutional. And it was an opinion by Justice Marshall, as I recall. And it's a subject of a good deal of discussion in Citizens United what the rationale for it was, because we all agree in this area that where you're talking about political speech, you're talking about a core First Amendment value. And if you're talking about a core First Amendment value, strict scrutiny applies. That is to say, there has to be a compelling governmental interest, and the compelling governmental interest has to be narrowly tailored to the ends of the statute. So that's the standard of all of these cases, and it passed muster in Austin. So that is to say, for the first time, the Supreme Court held that an expenditure limitation on a corporation where they were trying to publish a newspaper ad about a candidate that the Michigan Chamber of Commerce favored that limitation was constitutional under the First Amendment. Meanwhile, you heard a lot about the gestation of the McCain-Feingold Law, which is the actual name of it is the Bipartisan Campaign Reform Act. And when that case finally got to the Supreme Court, that is to say testing McCain-Feingold, or the BCRA, Austin became a very important decision. And it became an important decision because it was the linchpin for upholding, on facial grounds, the limits on independent expenditures for so-called electioneering communications, another term of art. An electioneering communication under the BCRA is not any communication. It has to be TV, cable, or satellite, and it has to occur within 30 days of a primary or 60 days of a general election, and in which case it is forbidden to do an independent expenditure in that 30-day or 60-day window. Enter Citizens United. Now, Citizens United is a nonprofit corporation that derives most but not all of its funds from individual contributions. It does accept corporate funds, albeit in a limited way. And they produced a movie called Hillary the Movie. And to say that it was critical of Senator Clinton is to understate it. It was a 90-minute so-called documentary, but it was a 90-minute diatribe against then Senator Clinton, with the voices of people like Dick Morris and Ann Coulter and folks like that, whose admiration for Senator Clinton was then and still is, as Secretary Clinton, under very firm control. And so it was, they brought a declaratory judgment action against the FEC, saying that what they wanted to do, they had this movie, this 90-minute movie, and it was available on DVD, no problem. It was available in movie theaters, no problem. But what they wanted to do is they wanted to make it available for video on demand. And there was a cable company that was prepared to enter into a contract wherein you could, for free, say, I want to see Hillary the Movie. And they had two ads that they wanted to run to promote this, a 10-second ad and a 30-second ad. And so they brought a declaratory judgment action in the District of Columbia and to declare that they could do this and that they could do this independent expenditure within 30 days of the Democratic primary when, of course, Senator Clinton, this was filed in December of 2007 before the Iowa caucuses. And under the statute, the McCain-Feingold, there was a provision for three-judge court being convened. So the day after they filed their complaint on December 13, a three-judge court was convened, chaired by our fellow alumnus and my classmate, Ray Randolph, who spoke at this very podium not so long ago. And he and two district court judges, on an expedited basis, had a preliminary injunction hearing. And there was a very, very limited record made, which I think maybe a discussion point a little later. And the three-judge court, in a per curiam opinion, doubtless written by my former classmate, because it sounds just like him, said, hey, we've got Austin, we've got McConnell, there's no likelihood of success on the merits. Shortly thereafter, so they denied the preliminary injunction. Shortly thereafter, motions for summary judgment were filed, and they were granted in favor of the FEC. The Supreme Court promptly noted probable jurisdiction, and given the important time constraints, the court set it for argument promptly after the elections in 2009. Namely, on March 24, 2009, there was a spirited oral argument, and since this is a CLE class, I want to take a few minutes to go over with you what happened in that first argument. And of course, the fact that I say it's a first argument implies that there's a second argument, and the reason that I make that implication is because there was. So at the first argument on March 24, Ted Olson was representing Citizens United. Of course, Ted Olson, a former Solicitor General himself, a very seasoned Supreme Court advocate, proceeded to make what were essentially statutory arguments. For example, that because it was a nonprofit corporation and it pretty much was entirely supported by individuals, that it should pass muster. And that was an argument that Justice Souter seemed to be attracted to, that only 1% of the money came from corporations to fund Hillary the movie. And then he tried to shoehorn himself into the Wisconsin Right to Life case, which was an advocacy, issue advocacy decision, which was favorable to the speech of the independent expenditure people. And he tried, actually, with a straight face from all I can tell, to say that this movie was really one whose purpose was to inform and educate, and that it was not really identified to a clearly identified candidate to advocate, in this case, her defeat for president. And of course, that was going nowhere. And but when he was asked point blank by Justice Scalia whether he was making a constitutional or a statutory argument, Olson said, yes, I am making a statutory argument in the sense that you will construe the statute in the ways that doesn't violate the Constitution. That was the essence of his claim, that for a variety of reasons it didn't fit the statutory definition of electioneering communication, or that it was the kind of corporation that you really should leave alone because of the de minimis corporate aspect, even though it was itself a corporation. Whereupon a deputy solicitor named Stewart got up, and he rose to please the court. And in short order, in colloquy with Justices Alito and, more importantly, with Justice Kennedy, he started his own version of the Great Chicago Fire. And it is so significant that I want to share a couple excerpts with you, because as you will later hear, it became quite decisive. So Justice Alito asked Malcolm Stewart, do you think the Constitution required Congress to draw the line where it did, limiting this to broadcast and cable and so forth? What's your answer to Mr. Olson's point that there isn't any constitutional difference between the distribution of this movie on video demand and providing access on the internet, providing DVDs either through a commercial service or maybe in a library, providing the same thing in a book? Would the Constitution permit the restriction of all those as well? Mr. Stewart replies, I think the Constitution would have permitted Congress to apply the electioneering communication restrictions. Those could have been applied to additional media as well. Justice Alito responds, that's pretty incredible. You think that if a book was published, a campaign biography that was the functional equivalent of express advocacy, that could be banned? Mr. Stewart, I'm saying that Congress could prohibit the use of corporate treasury funds and could require a corporation to publish it using it gets cut off. Well, most publishers are corporations, says Justice Alito, and a publisher that is a corporation could be prohibited from selling a book. The government's position, he replied, is that the First Amendment allows the banning of a book if it's published by a corporation. Justice Kennedy, your position is that under the Constitution, the advertising for this book or the sale for the book itself could be prohibited within the 60, 90-day period, the 60, 30-day period? Mr. Stewart, if the book contained the functional equivalent of express advocacy, That is, if it was subject to no reasonable interpretation. Justice Kennedy. And I suppose that it could even, is it the Kindle where you read the book? I take it that's from a satellite. So the existing statute would probably prohibit that as well. Mr. Stewart. Well, the statute applies to cable, satellite, and broadcast communications. Justice Kennedy. Just to make it clear, it's the government's position that under the statute, if this Kindle device, where you can read a book, which is campaign advocacy, within the 30-day period, if it comes from a satellite, it can be prohibited under the Constitution and perhaps under this statute. Mr. Stewart, a corporation could be barred from using its general treasury funds to publish the book and could be required to use to raise funds to publish the book using its PAC, Political Action Committee. Chief Justice Roberts. So if it has one name, just one use of the candidate's name, it would be covered, correct? Mr. Stewart, that's correct. Chief Justice Roberts, it's a 500-page book, and at the end it says, so vote for X, the government can ban that? Mr. Stewart, well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provisions. Well, as you can imagine, that prompted a further order from the Supreme Court. And that further order came down, and it was addressed and asked the parties to file supplemental briefs on the subject of whether Austin and McConnell should be overruled, and it set a re-argument on September 9, 2009. So by September 9, 2009, a couple of things had changed. First of all, oddly enough, Mr. Stewart wasn't there. But General Kagan was. And when General Kagan was asked, what about those books, asked Justice Ginsburg, she says, oh, the government has changed its position on that, and the FEC would never ban a book, she promised. Well, other people were there who weren't there before. Ted Olson was still there, but now we had Floyd Abrams, who was representing Mitch McConnell, and we had Seth Waxman, who was representing John McCain, as well as General Kagan herself. And so she backed off on the issue about books as fast as she could. Of course, Justice Souter was also gone by that point, and Justice Sotomayor was there instead. And the damage, however, was clearly done. And as a result, Justice Kennedy, writing for the majority, overruled Austin, overruled that part of McConnell that was premised upon Austin, and the holding of the court, which I will read to you without further ado, is as follows. It's on page 50 of the slip opinion. And it says, forgive me, it's 188 pages of opinions here. We return to the principle established in Buckley and Bellotti, which was a referendum case, that the government may not suppress political speech on the basis of the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. Further, it held, the McConnell court relied on the anti-distortion interest recognized in Austin to uphold a greater restriction on speech than the restriction upheld in Austin, and we have found this interest unconvincing and insufficient. This part of McConnell is now overruled. So I think it's a study, among other things. We'll talk about the policy aspects, which I know have divided people from our president through Justice Alito face-to-face in that State of the Union experience. But I think it's fair to say that what started out as a narrow statutory construction issue through the blunder of an advocate, changed it quite radically. And in fact, a blogger the day after the first argument said, and there's a lot of truth to this, but I defer to Kim and others, Steve, who clerked on the Supreme Court, whether they think this is true, that it's hard to win a case in the Supreme Court, but it's very easy to lose it. And I think that may be exactly what happened, courtesy of Mr. Stewart. So that's the case.
Okay, thank you so much for both a wonderful elaboration and a striking object lesson. Let me begin with the proposition that this is not a straightforward issue, either politically or legally. Politically, state limitations on corporate political expenditures and contributions began in the 19th century at the state level as part of the progressive reaction against corporations that later led to things like the Sherman Antitrust Law. Federal corporation limits on corporate political expenditures began with the Tillman Act of 1907. But that said, much of the impetus behind the modern exclusion of corporations and unions from political expenditures began in the Taft-Hartley Act of 1947, which was fundamentally an effort to constrain the overweening power of unions, a position that seems a tad quaint today. The modern wave of political campaign finance limitations or campaign finance reform began in the aftermath of Watergate. But the ACLU's experience of that era inclined it actually against the limitations. Their experience was that the somewhat anemic campaign finance regulations under which the Nixon administration functioned provided a fine basis upon which to try to suppress criticisms of the Nixon administration around the time of elections. Indeed, they had a series of cases in which the Nixon administration induced the FEC to go after people who would criticize President Nixon for bombing Cambodia or failing to engage in desegregation efforts or calling for his impeachment. All were considered to be electioneering communications. So I should add, I just talked to a corporate law colleague coming over who said that he thought this was fundamentally an anti-corporate decision because, in fact, corporations engage in all kinds of political activities under the regime that preceded Citizens United, but they were allowed to tell politicians, sorry, we can't help you, we are barred. So he actually saw this as something against the interests of large corporations. So politically, it's a mixed bag, as Andrew will argue. In fact, on the ground, it gets more mixed still. Legally, as Judge Dalzell says, modern campaign finance law, beginning with Buckley versus Vallejo, has always been a somewhat uneasy compromise, drawing lines between contributions and expenditures, between electioneering and issue advertising, between PAC contributions and direct expenditures, between soft money and hard money, political advocacy organizations and commercial corporations that have been less than precise and often less than intuitively compelling. In the last 2 decades, there's been a constant refrain on the court that has called for the elimination of Buckley's compromises. The problem is that while there have been strong arguments by justices that all regulations of political expenditures, and for that matter contributions, are entirely inconsistent with the First Amendment's protection of free speech, there have also been an almost equal number of justices counterbalancing that with the position that Buckley provides too much protection and that expenditures by corporate interests and contributions to candidates by large aggregations of wealth threaten the core of American democracy by engaging in something that is not speech but rather action, the donation of money. So for the last generation, campaign finance regulation at the constitutional level has been founded on an uneasy compromise. And at both the state level and the federal level, a large structure has grown up around that compromise. In 2003, the issue came to the Supreme Court In McConnell against FEC, where a challenge to the McCain-Feingold Campaign Finance Act generated an apocalyptic confrontation and a 100,000-page record at the trial court level to try to determine whether indeed overwhelming public necessity did justify the sorts of compromises or the sorts of interventions that were on the table. The majority of the Supreme Court held that it did, that Buckley would remain the uneasy compromise, and that the McCain-Feingold Act, for the most part, survived. There were three strong dissents: Justice Scalia, Kennedy, and Thomas. Justice Rehnquist, who filed a somewhat more equivocal dissent. Although Justice Rehnquist had long taken the position that corporations did not have the same First Amendment rights as natural persons, because as a condition of the corporate form, they could be required to waive certain sorts of rights. This is consistent with his position on unconstitutional conditions doctrine. Well, comes now, Judge Dalzell sees the crucial actor as Assistant Solicitor General Stewart. I see the crucial actors as the replacement of Justice Rehnquist with Justice Roberts and Justice O'Connor with Justice Alito. During the period of the beginning of the Roberts Court, there were a series of cases that chipped around the boundaries of the Buckley Compromise. Randall against Sorrell, 2006, struck down Vermont's limitation of $200 as a maximum contribution for statewide office. FEC against Wisconsin Right to Life invalidated a portion of the McCain-Feingold application to ads of certain sorts as an as-applied basis. Davis against Federal Election Commission, 2008, invalidated the Millionaires Amendment, which put in place certain limitations that counterbalance people who self-financed campaigns above $350,000 of expenditures. And as Judge Dalzell says, when Citizens United was initially brought to court, its attorneys argued primarily that the statute in question, the McCain-Feingold Act, should not be interpreted to cover the particular movie, or that if it did, it was unconstitutional as applied to this particular organization, this particular movie. What they didn't do was to maintain that the prohibition or limitation on corporate expenditures was itself unconstitutional on its face. Indeed, they dismissed with prejudice a count of their complaint claiming that the statute was unconstitutional on its face. They did not challenge the settled practice running back to 1907 of tightly limiting commercial corporate expenditures. They didn't challenge the settled law of the Austin case or its reaffirmation in McConnell. No record was made regarding the existence of dangers from corporate expenditures, the impact of the limitations on the actual ability of corporations to engage in political speech, or any of the other facts that one might want to address if indeed this was a challenge to a substantial piece of the corporate governance of the United States running back to 1907. Nonetheless, when the case reached the Supreme Court, again, Judge Dalzell sees this as the misstep of General Stewart. I see this more as the triumph of Justice Kennedy, who had repeatedly expressed his desire to overrule Austin and indeed much of the Buckley against Vallejo edifice. When the argument took place, the Supreme Court asked for argument as to whether the Austin case and its 2006 determination in McConnell should be overruled, whether the statute on its face should be invalidated. As you heard, Justice Kennedy commanded a majority of 5 for the proposition that Austin should in fact be overruled and that the limitation on corporate expenditures was unconstitutional on its face. I want to highlight three elements of his decision that I, as a professor of constitutional law, come away more than a little concerned about. First of all, Justice Kennedy's argument rested in part on the claim that Section 441, the limitation on corporate expenditures, involved a vast censorship. These are his words. A vast censorship, quote, that has muffled the voices that best represent the most significant segments of the economy. And he said that the electorate has been deprived of information and knowledge and opinion vital to its functioning. Well, this seems to me a somewhat debatable conclusion. Citizens United and any other corporation is free under the under the McCain-Feingold Act to form a pact and spend money it raises from its officers and employees. The officers and employees are free to bundle funds in several different ways, in multiple different ways, in ways that make the most complicated of trust agreements you can imagine look simple, and to aggregate funds. Any individual owner of a corporation that is burdened by the expense of having to set up a PAC can simply make expenditures in his or her own name. And as a matter of real-world observation, for example, the airwaves around the recent healthcare debate, it doesn't seem clear that there's a lot of muffling of important corporate speech. Indeed, it doesn't seem obvious that our society suffers from a dearth of political advocacy. But the proposition was resolved on the basis of a record that didn't exist. Second, Justice Kennedy's conclusion depended on the proposition that independent expenditures by for-profit corporations pose no substantial danger of corrupting the political process. There was an acknowledgement that if there's a real danger of corrupting the political process, then there is a basis for intervention. Or, he said, of causing the electorate to lose faith in our democracy. Now, both of these, again, are empirical judgments. And one might think that the issue is appropriate for empirical investigation. Indeed, on the question of the possibility that independent expenditures can generate corruption, there is a leading example that Justice Kennedy wrote the same term in the Caperton case, right, where the West Virginia Supreme Court was populated by a justice who was elected by virtue of independent expenditures by Don Blankenship of Massey Cole. Massey Cole has a $5 million verdict before the West Virginia Supreme Court. It's a 3-3 split. They elect the favored candidate is elected by virtue of $3 million of political expenditures. Again, Justice Kennedy in that situation says there is at least a doubt about whether the justice at issue can sit because, as a matter of due process, he is at least apparently corrupted. But nonetheless, Justice Kennedy resolves the matter here without benefit of trial, without benefit of record, on the ground that there are 26 states that don't restrict expenditures by for-profit corporations, and the government doesn't claim that these expenditures have corrupted the political process. This sort of rush to judgment, resolving debatable empirical questions as a matter of fiat, strikes me that it does no credit to the court and plays all too easily into a narrative that makes the court's decisions the reflex of the raw judicial ideology of the particular justices who sit on the court rather than of reasoned decision-making. So that's a reason for concern. Third, let me say a few words about Justice Kennedy's legal arguments, and I'm going to cut off shortly. The argument that the corporate expenditure limitations that were upheld in the Austin case were outliers, inconsistent with Buckley against Vallejo that Justice Kennedy makes, is a remarkable piece of revisionist history, since the plaintiffs in Buckley, who brought every conceivable challenge to the statute, didn't even bother challenging the limitation on corporate expenditures because the law and practice was so well settled. Justice Kennedy is entitled to overrule settled precedent, but I object to his denying that he's doing so. The larger problem is that the principle upon which the case turns is that the First Amendment is implacably hostile to discrimination on the basis of the identity of the speaker. Now again, as an ACLU attorney, I kind of like that one. But as a constitutional law professor, observing the fact that the rights of students are diluted because they're students, the rights of prisoners are diluted because they're prisoners, the rights of members of the military are diluted because they're members of the military, and the rights of public employees are diluted because they're members of, they're employed by the public. It strikes me that there is a bit of an inconsistency with the claim that the First Amendment can never take into account the identity of the speaker. Now, it goes too far to say that corporations have no First Amendment rights. Certainly the New York Times Corporation or the book publisher has First Amendment rights. But it certainly does not seem consistent with the fabric of the First Amendment principle to refuse to investigate the merits of the question of whether the real-world impact of adjusting the rights of corporations in particular ways, perhaps only rights of commercial corporations, in order to accommodate concerns of corruption, is outside of the competence of the Supreme Court. Yours.
This is great. I'm actually in the position to be able to argue constitutional law against the guy who taught me constitutional law. As Professor ACLU mentioned, I'm not a professor. I'm not a constitutional law scholar. I'm certainly not a federal judge. For those of you who watch Monday Night Football, I figured I'd be sort of the Tony Kornheiser of the panel and just kind of be the working man, telling you about how this decision will affect, or I think will affect, or what's going to happen on the ground. So maybe we can go about 2 blocks west of the Supreme Court over to Congress and look at 535 election campaigns. Judge Dalzell mentioned something that I was going to mention at the outset, and that is this distinction between contributions and expenditures. And I think that largely has been lost in a lot of the debate, and that's a frustration because contrary to a lot of this Chicken Little hysteria about billions of dollars flooding into campaigns, I don't see that happening. It's in fact not happening, and that is, I say that 6 months away from historically the most volatile potential election campaign you can possibly have, and that is the midterm of a first-term president after a party switch in the White House. I mean, this is historically where you would see the largest influx of funds, the most active political base, and we're just not seeing it. You're not seeing Pepsi-Cola running ads about supporting members of Congress. You are not seeing that happen. You're not going to see that happen in my view. One other thing that I want to mention on sort of the whole contribution expenditure paradigm is Professor Kramer mentioned that I was a campaign consultant. I managed a few campaigns, and I will tell you this: there is nothing that I am more hostile to as a campaign consultant than independent expenditures. As the judge mentioned, they must be, by definition, without the cooperation or consent of the campaign. They are wholly independent. Now, we live in a time when, as a campaign manager, I can target an ad to white families where the dad is 30 to 35 with a kid who plays softball and drives an SUV and is a member of a gym. I can be very granular about how I target my message, exactly where I target my message, precinct by precinct, how it's going to resonate. I've done extensive polling, and there is nothing that ticks me off more than some jerk with a bunch of money coming in and running an ad because he thinks it's going to help. It usually won't. So practical point number one to keep in mind is that these independent expenditures are not necessarily going to be supportive of the campaigns. And in fact, if you ask most campaign consultants, I think they'll tell you quite the opposite. The other thing that I want to talk about, and trying to be mindful of time, they really threatened us on not cutting into Dean Fitz's State of the Law School address, so we have to get out of here in 11 minutes. Again, I was taught by somebody 12 years ago that strict scrutiny required a compelling government interest in a narrowly tailored solution. I don't know, it looks a lot like the guy sitting to my right.
Actually, no. I'm very skeptical of this levels of scrutiny routine.
Well, you still taught it, and it's and as the judge pointed out, the court it is wholly uncontroversial that political speech is subject to strict scrutiny. The Buckley Court identified corruption and the appearance of corruption as the compelling government interest or the necessary government interest in that case. And by corruption, what they identified was sort of the risk of quid pro quo, exchanges of money for political favors, and this is how they sort of distinguish between contributions and expenditures. What the Austin court did was sort of take this very, in my view, radical step of extending the government interest to the corrosive and distorting effects of immense aggregations of wealth. So we need to keep that in mind when we're analyzing, the rationale behind Austin. They are talking about going after immense aggregations of wealth. That's what we're trying to avoid. So let's look at that. As Professor Kramer said, the Tillman Act in 1907 is where you first saw, or the genesis of a lot of this ban on corporate money in politics. At the time, the corporate form was extraordinarily rare. There were very few corporations out there, and the ones that there were in fact immense aggregations of wealth. Now you fast forward 100 years later, we now have 6 million corporations in the United States. 81% are under $1 million in revenues, and 96% are under $5 million in revenues. So to the extent that you're trying to narrowly tailor an avoidance of immense aggregations of wealth through a ban on corporate contributions, you're missing the boat by just banning them across the board. That is just, it does not fit with the rationale that the government, in the first argument, stood by and then abandoned as the case went on. The under-inclusive point is that Austin's rationale, if you're trying to look for immense aggregations of wealth to be outside of the political world, well, you've got an awful lot of rich people out there that are non-incorporated. They're either individuals, or they're partnerships, or they're limited liability company. There are a lot of unincorporated corporate business forms that do not fall within the 441B ban, and therefore are outside of Austin's rationale. And the problem with that is, you've got folks like Ross Perot, George Soros, T. Boone Pickens, who ironically made all their money through corporate wealth. They all got it through distributions and stock options and other ways of making money as a corporation, turn around as individuals, and they are injecting that immense aggregation of wealth into the political process that the court in Austin seems so exercised about. And that sort of leads me to what is going to have to be my final point, and that is to look at the client that I represented for the amicus brief that I was fortunate enough to draft in this case, and is a C4, a 501c4, which is a social welfare group, basically a political advocacy corporation called the American Justice Partnership. And what AJP does is fight against what they call runaway litigation, excessive damage awards, and irrespective of how you might feel about that position, it's certainly a perfectly rational position to take. And they, by virtue of being a C4 with members who are small businesses, are prohibited from participating in the political process in the same way that individuals and unincorporated entities can. Well, who are their opponents? Their opponents are trial lawyers. Trial lawyers generally don't incorporate. They are wealthy individuals, or they're under corporate form, under a partnership or something along those lines, where they're not subject to the same restrictions that were present prior to the Citizens United case. So here my client is a small nonprofit with revenues under $3 million for statewide advocacy in all 50 states, and they are prohibited from speaking. But on the other side of their issue, they have trial lawyers who, to take an example, the litigation team in the tobacco settlement in Florida, each lawyer got $223 million personally. Now, if the Austin court was so concerned about immense aggregations of wealth distorting the political process, they're certainly missing the boat when it comes to a situation like AJP and the trial lawyers. I'm not sure it's the same, sort of constitutional argument that Professor Kramer was talking about, but I thought it was important just to look at how, in practice, if we're trying to level the playing field, if we're trying to regulate or at least prevent distortions of speech, Austin certainly didn't do it. And the Citizens United decision in that respect is going to do, in my view, one and only one thing, and that is change the opportunity for smaller organizations, smaller nonprofits organized under C4 to enter the political process, And in that way, all that decision really does is say that individuals who independently can't afford to buy a television ad or can't afford to buy a newspaper ad can now pool their resources and enter the political process in a way that certainly is not going to distort that political process, is to the contrary, actually going to get out a contrary point of view, which is perfectly valid. A couple of other quick things that I'll mention only because Professor Kramer brought it up. We talked, the dissent did talk, as you did, about the PAC solution, the Political Action Committee solution. Again, 6 million corporations in the country, 2,000 PACs. It's not workable. The administrative burdens of PACs are excessive. How do I know that? I make a lot of money doing it. Trust me, people have to pay me to do a lot of time, a lot of hours, a lot of energy to register, to track, to account, to report. It is staggering how difficult it is to open and operate a political action committee. It's just simply not a viable solution. I'm going to skip, since we didn't talk about MCFL, right? Not really. We'll skip that. So that's about it. I mean, I'll just close with a prediction that if you are anticipating seeing a massive influx of corporate dollars by for-profit corporations, I think that come the first week of November, you're going to be sorely disappointed. It's just not going to happen.
Jim, you want to try 5 minutes?
Are we supposed to really stop at 5:30? I'm just
We'll
not.
wait till we get the hook.
I don't see anyone out there, so why don't you start at
We did.
Well, I'll try to be brief, and I'm going to talk actually at a very high level of generality, so it won't require you to focus on any particularly fine distinctions or complicated statutory language or even actual cases. All I'm going to say is, from a very general perspective, how might we think about corporations and the First Amendment and what judges should be doing and the role of elected officials? So let's assume, right, we're concerned with the First Amendment because we want to protect a good environment for democratic deliberation. We're not concerned with the First Amendment as a means to individual self-expression and human flourishing, right? If we were thinking about that, we probably wouldn't care very much about corporate speech because corporations are not people in the sense, we don't care about their flourishing. So we're concerned about sort of a good environment for democratic deliberation. How should we think about corporate speech from that perspective? Well, one thing you might think is information is good, more information is necessarily better, so restrictions on any kind of speech should be unconstitutional. If that's true, if it's true that more information is necessarily better, then yes, right, the conclusion follows, okay, we should strike down restrictions on anyone's speech. But, I would say, that's not true. It's pretty obviously not true. We can distinguish between good and bad speech if we're talking about speech that is crucial for democratic deliberation. So what's good speech? Well, good speech is speech that is conveying crucial information accurately, or speech that is based on a dispassionate assessment of the public interest. Now, we're not necessarily going to get a lot of that kind of speech. Probably people care more about their own interest than the public interest. But still, speech that is intended to promote the interest of the person speaking, maybe that's still pretty good. If you get a lot of that, maybe you can aggregate it and sort of get a picture of the public interest. So those are good kinds of speech. What kinds of speech are bad? Well, misleading speech would be bad, obviously, if it makes people form false factual beliefs. And I think speech that achieves its effect through repetition rather than persuasion is probably bad too. If one message is just drowning out everything else, it's probably undesirable. So we can, in fact, distinguish between good and bad speech from the perspective of self-governance and democratic deliberation. We don't tend to see those distinctions in our First Amendment case law, though. And we do sometimes see judges saying things like, more speech is necessarily better. So why do they say that? Well, the idea here is really, I think, not so much that more speech is better, but that we don't trust the government to make a distinction between good and bad speech. And why is that? Well, the most obvious reason is there's a big conflict of interest that could arise. One of the things that you use speech for in a democracy is to change your government, to throw the bums out of office. So the big obvious concern we would have if we let the government distinguish between good and bad speech is government officials will use this power to protect themselves. They'll use it to try to silence critics. So what do we have now? Well, what I've said so far is there is a distinction we can draw between good and bad speech and there's an obvious reason why we don't trust the government to make it in most cases. But our corporations may be different, right? Could the identity of the speaker make a difference? Well, I think it might, for these reasons. What kind of speech is a corporation likely to produce? It should not produce speech that is based on a dispassionate assessment of the public interest. Why not? Well, because if you're talking about for-profit corporations, publicly held, that's mostly what I'm focusing on here. Directors and officers actually have a legal duty to maximize shareholder wealth rather than try to promote the general public interest. So what about the second best kind of speech? Speech that promotes the interest of some particular individual? Well, again, corporations aren't people, right? So when we're thinking about the government making policy to benefit the public, corporations actually are not on their own members of that public whose interests the government should be taking into account. Now, maybe when you promote the corporation's interests, you're promoting the interests of its shareholders. You know, in a limited sense, that's true. You're promoting their economic interest as far as their stock holdings go. But for most people, their stock holdings are not actually the main source of wealth. And of course, people have non-economic interests. So I might hold a little bit of British Petroleum stock. I might care more about the environment than seeing that stock go up. So corporate speech is not likely to match up perfectly with the interests of any flesh and blood people, except perhaps officers and directors who have a large amount of their personal wealth in that corporate stock. But those people tend to be rich and can speak pretty easily on their own. So corporate speech, I think, is not likely to be crucial, right? It's not likely to be especially valuable. And as Professor Kramer said, I don't think that we have a lack of political advocacy going on. Might it be bad? Well, you know, you can argue back and forth about distortion. I think there's at least a possibility of distortion. And I think it's significant that corporate speech is not going to match up with the interests of flesh and blood people to whom government should be responsive. So for those reasons, I would tend to be a little bit more accepting of the idea of government regulation based on the corporate identity of the speaker. At the least, I would want to try to get a finer-grained sense of what the facts on the ground are going to be. And that's a quick, high level of generalities.
Beth, how are we doing?
In the back of the room.
Yeah, we are being dragged off. We thank you for your attention.